of the things about our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, it's just JV it. Like, what the hell does that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly, Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Good morning, everybody. Welcome to the show. Today, we're talking about using powers of attorney in real estate and personal finance. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to give us a like. You can find us on YouTube, Facebook, X, formerly known as Twitter. At all of those locations, we can be found at the handle @InRem Podcast. That is @InRem Podcast. Also, you can download an audio version of the podcast. You can find it on Apple, Spotify, and all the other major podcast platforms. With that, we're going to go to Sean, who has our legal update.
Thank you, Andy. So my legal update today is basically how to use a land trust to gain full anonymity. So I always have clients coming to me saying, hey, Sean, how, do I stay anonymous on my transactions? And in particular, subject to transactions. How do I stay anonymous on my subject to transactions? And the reason why that is hard is because whether you're doing a seller wrap carryback or you're doing a agreement for sale, at some point, if you're buying it in an LLC, even if it's an anonymous LLC, like a Wyoming LLC, and you're buying it in the name of that entity that you're trying to, have a certain level of anonymity so nobody knows who's behind the LLC, at some point, you have to basically get to the bottom line and the final person to execute that document. LLCs can only act through human beings. And so at some point, somebody has to sign their name to that document on behalf of the LLC, whether as a member, a manager, or an authorized representative. Somebody has to do it. Well, most of the time, it's going to be the owner of the company who may sign as the authorized representative. Well, then it's like, well, what's the purpose of anonymity when we record a wrap? I sign the mortgage or the deed of trust and it gets recorded and you can see my name there on that document. Or what happens in an agreement for sale where, or a land contract where I go and I sign my name as the purchaser or on behalf of the LLC, the purchaser. Well, my name's there. Like that's the whole purpose of anonymity, is that they don't know who's behind the LLC. So how do you avoid that? Well, one way you can avoid that is through a land trust. And last week I talked about the fact that you never want the seller/borrower to be the one who creates the land trust, who funds the land trust, because they will be deemed the grantor or the settler of the land trust. And then the land trust and the property put in the land trust will remain liable for that seller/borrower's debts and obligations going forward. And so you don't want to do that. And then I talked last week about the fact that I'm going to talk about this anonymity process here and how you can do that. So the way to gain anonymity using a land trust and at the same time not basically subjecting the land trust and the property in the land trust to the debts and obligations of the seller/borrower is to do it this way. So basically, if you are under contract, you enter into the contract under whatever entity, LLC that you're normally going to buy under. And that will be the initial buyer under the contract. And then what you do from there is you basically create a trust, and you generally will title the trust with the name being the address of the property. So 1854 Mulberry Drive, revocable trust is what the name of it would be, for example. So you just put that on there, and that's the name of the trust. You make your LLC, which presumably would be a Wyoming or Delaware LLC. You make that LLC the beneficiary of that trust. And then for the trustee, you make the trustee either an attorney, a private fiduciary that will serve as trustee, or you could even make the seller the trustee of that land trust on a temporary basis, but you make the seller the trustee. And then you assign the purchase contract to the land trust so that the land trust is the actual buyer. And so the land trust is actually the one that's going to buy the property from the seller. And so then the property goes from the seller to whoever the trustee is. So if it's the seller, then it would be the seller as trustee of 1854, Mulberry Drive Revocable Trust, or to, Sean St. Clair, Esquire, as trustee of the 1854 Mulberry Trust, Mulberry Drive Revocable Trust. But it basically goes to the trust that way. And then from there, when you're going to execute the mortgage, for example, or the deed of trust, the land trust would be the borrower, and then the party signing the land trust would be the trustee. So the seller as the trustee could sign, or the private professional trustee that you've put in place can sign on behalf of the land trust. And so when now somebody looks at the documents, they just see this either private fiduciary or the seller as trustee, and they do not know who's behind the land trust. Now, in Arizona, and this is why it's important to make sure that your LLC is the beneficiary of the land trust, because in Arizona, every transfer to or from a trust, you have to disclose. It's a requirement. You won't convey good title if you don't do this. You have to disclose the names and addresses of all beneficiaries of that trust. So that's why it's important to use your LLC as the beneficiary, your Wyoming or Delaware LLC as the beneficiary. So it will have, XYZ LLC, a Wyoming limited liability company, as the beneficiary with the address of whatever stat agent you're using in Wyoming, for example, listed as the address for the LLC. That is basically how you can obtain anonymity using a land trust. Now, what happens to that trustee that you've appointed? Let's say you've appointed the seller as trustee. Well, you don't want the seller to remain trustee post-closing. So part of the closing packet that you have would be a resignation of trusteeship. So they would resign as trustee, and then the trust would provide that then you become the trustee of the trust at that point going forward. And so the seller would resign. They would sign a resignation that's notarized. They resign as trustee, and it flows down to you as trustee, or you can even have the private fiduciary resign after closing, and then the trusteeship would flow down to you if you've designated yourself as the successor trustee in the trust. So basically, that's how to use land trusts to gain full anonymity. If you want anonymity and want to make it so that nobody can look at the public records and see the individual that's behind any particular real estate transaction.
All right. Thank you, Sean. With that, let's go into a couple of announcements. Make sure to join us today and every Tuesday at 2:00 p.m. You might notice from our previous announcements, instead of saying 3:00 p.m., we're saying 2:00. We've adjusted the time here in Arizona to accommodate daylight savings times in some of the other states and attorneys that are participating in the Creative Finance Collective. So if you're in Arizona, it's 2:00 p.m. Arizona time right now for the time being, every Tuesday. So what is the Creative Finance Collective? That is a collection and a membership of attorneys in the space of creative finance. What we do is we get together and we talk about all things creative finance and real estate related. This is our opportunity to see what other states are doing, how other jurisdictions are treating the topic of creative finance, how different lawyers are handling the transaction and the forms. It gives us an opportunity to make our forms better and just to work through and discuss the topic. But more importantly for you, the listener, we make ourselves available for the entire hour for questions to you. So we're captive to you. So we'll be on until we stop getting questions. So if you have thoughts or you've run into problems and you're wondering how these transactions work, we and other members of the collective are here to talk through that with you, answer any questions, and use your questions as discussion points for our discussion going forward. Even gives us future topics that we might address if it's a complex enough of an issue or question we think needs to be addressed. So make sure to join us, 2:00 p.m. You can find it on YouTube, Facebook, or X. Watch it live, and we'll take your questions there. Also, if you have questions today, again, we're talking about powers of attorney and how that helps in personal finance and how that works in real estate. If you have questions on that topic, we'll be taking any questions in the final 15 minutes of this episode. So you don't need to wait till the end of the episode. Go ahead and place the questions in the comments of whatever platform you're on. We're monitoring those, and we'll get to those questions as the time comes. All right, with that, let's get into our topic. So we're talking about using powers of attorney in real estate and personal finance. And with us to discuss that topic is Robert Sewell. To us, he's Bob Sewell. Bob, do you like to go by your formal Robert? Like, I'm Andrew, but I like to be called Andy. Do you like to be just referred to as Bob? That's how I've always known.
Everyone calls me Bob.
All right.
Yeah, I gave up being Robert a long time ago. When you got a name like Robert, it's Bob, it's Bobby, it's Rob, it's Robbie. No one calls you Robert, you know?
So Bob here is a partner with the law firm of Davis Miles. Tell us about Davis Miles and what that firm focuses on.
So it's a full service law firm, and we do just about anything in the Valley. We have offices in New Mexico and Utah, and here in Tempe we have an office. And if you can think of it, we do it. That's what we have.
Full service law firm. Bob, tell us about your individual practice. What areas of law do you focus on?
Yeah, so I have a little bit of a niche where I practice in probate and trust litigation. And I pretty much deal with anything involving death and dying that arises. So there's a problem with the business, because someone is dying, I will come in, or someone has died, I will come in and help you make the transition. If there's a creditor's claim against an estate, I will prosecute the creditor's claim. Or you want to defend against a creditor's claim, I'll defend against that. It's a huge variety, including will disputes, trust disputes, things involving undue influence. Once someone is dying or there's death, then the rules start to change, and you have to look for new tools. And those tools is what I use to help my clients.
Now, Bob, I know you have a pretty fun and interesting podcast. Why don't you tell our listeners about that and what you address on that podcast?
So it's called Is That Even Legal? And what I do is I bring on a guest and we talk about something current in the law, generally something that's going around on the internet or in the news, or a recent case. And we apply it to some story that we're hearing about, or, and we talk about it. So one time I was getting a lot of questions about noisy neighbors in the office. And so like one time we did an episode on how to get rid of your neighbor, because it just so happens that I was kind of good at getting rid of neighbors. And I had a personal problem like that. And I'm like, how do I get rid of this guy who is just so horrible? And so we talked about it. In addition, we talk about asset protection and like we talked about the Gilbert Goons recently. And well, what's interesting about that story here in Arizona, and for those who don't know, typically upper middle class to wealthier kids going out and doing vigilante things, pounding on other kids just for fun. And then what kid dies? And the what ends up happening from a civil standpoint, in addition to the tragic death of a child and the beatings of other children, from a civil standpoint, the parents of these rascals, these knuckleheads, begin to incur civil liability. And everyone's like, well, wait a minute. Yeah, that's right. If you got a nasty little kid and you know about it, you might end up having a discussion about your liability for your kid's naughty behavior.
Parents might have responsibility for the actions of their kids. Shocker.
Yeah.
All right. Well, in that same vein, in talking about acting or being responsible for the actions of another, today we're talking about powers of attorney. And I know in probate, estate planning work, real estate, I know you've done a good bit of real estate in your career as well. Powers of attorney are a big part of it. And we're gonna flesh it out and get through a lot of the details as we discuss this topic. But why don't we just start at the ground floor for a listener that might just be coming to this topic at the very beginning with maybe just a very rudimentary sense of what this might be. Explain for our listeners, what are we talking about when we say a power of attorney? What is that?
So a power of attorney is when a person grants an agent authority to act in their name. There are two general types of power of attorney. There are the general and durable power of attorney. Sometimes the durable is referred to as springing. It just depends on your jurisdiction and your legal tradition. But basically, those general and durable, those springing powers of attorney come to life when I become incapacitated, when I'm no longer able to speak for myself. Very important. So it helps you manage your business life, your bank accounts, your real estate, et cetera, so forth. And then there's the second type is your healthcare power of attorney. And these powers of attorney help you manage your healthcare when you're no longer able to do so. Very important. Both of these, I cannot, one of the things I do in my practice is guardian conservator work. And so that's someone who fails to plan, fails to come to someone like Andy Fowler and get an estate plan. And so when I fail to plan, one of the things you fail to do is get those general and durable and healthcare powers of attorney. And your life has got a lot more expensive because powers of attorney are relatively cheap. Guardian conservator work is very expensive. You're going to start out about $4,000 to $5,000 a year, and it's going to go up more depending on the complexity of your estate.
So let's talk about a little bit how it's created and how it differentiates itself from other types of, I guess, what we might call agency appointments. The law recognizes any number of ways to potentially create some sort of agency relationship. We have statutory agents with limited liability companies, which is, an agency relationship. The law even recognizes my ability to represent to somebody that Bob Sewell has the authority to talk on my behalf today or something, and that might be construed as an agency relationship. How does the power of attorney differ from that, or does it? Is it just a more formalized version and concrete version of the creation of a principal and agency relationship?
It is exactly that, a principal and agency relationship. It's the principal is appointing the agent to act on your behalf. And the way you are able to act depends on the powers granted in that power of attorney. So if you have a very limited power of attorney, the limited things in there, then you're going to have very few things that your agent can do for you.
Well, let's talk about the actual power of attorney document itself. Because as Andy was saying, I mean, you can have a verbal agency relationship, but the power of attorney really cements that and allows it to be used in a number of circumstances. And we'll talk about that in a little bit. But if I were to come and say, okay, create a power to an attorney and say, create a power of attorney for me here in Arizona. what are some of the things that you need to basically create that formal agency appointment, that formal document?
So it has to be clear inside the document that you're creating an agency relationship. That's first of all. And generally, you're going to need the signature of the principal, a witness, and a notary. Generally speaking, that's what you're going to have. Now, it might be other things might be required in other jurisdictions, but inside of Arizona, that's what you have to have. And so, and there's some language that you have to use inside of Arizona, and there's a reason why I write these things down and don't try to remember them, but that are effectively explaining to the world that you're creating an agency relationship. And so Arizona wants some magic words in there, and other jurisdictions will require other things. But yeah, witness, signature of the principals, and notary block.
Well, what about capacity? What level of capacity must somebody have to actually create a power of attorney?
Yeah. So this is one of the things that it's a very much a frustration for people right now. As the silver, and I want to talk about capacity, and I'll answer your question. Hey, don't get pushy, okay? I'll answer your question.
Okay.
We
have an hour. We have half an hour now. So
I want to set this up. The silver tide is real. The aging of America is real, and it's creating significant problems for people. And the actual level of capacity to create an agency relationship is very, very low. You have to, one, understand the act that you're doing. You have to understand what it means to create an agency relationship. So, and it's not an extraordinary understanding, right? You don't have to have, lawyer understanding of what's going on. You have to have, oh yeah, I'm making someone my power of attorney. That's about it. That way they could go take care of my business. I mean, that's about all you need to know. And then you have to understand the natural objects of your bounty. In other words, who are your loved ones? You got to know who they are. You got to know what's going on. I have 3 kids. I have, I have a wife or a girlfriend or whatever it is in your life. And then you have to understand the extent of your property. So the problem, a problem arises though with this stuff is because you don't know, like as the attorney, they come in, they say, you've never met this person. And they're like, I got 3 kids. Well, they have 4, right? I have a house in Mexico, a house in Alaska, and a house in Arizona. Well, they sold the house in Mexico and they have a house in Colorado now. You don't know that though, right? And unless you have good, careful attorneys who are there to protect people, who are ethical, who are more interested in doing good, a lot of people are making powers of attorney that shouldn't be. And the other thing, so it's just you only need that 3 level of capacity. Know your assets, natural objects for your bounty, understand the act. That's all you really need. Very low level, but it ends up spilling over if the power of attorney is not benevolent, is not acting on your behalf.
So let's break down some of the differences that we might see in powers of attorney. And you talked a little bit about this, and we're going to get more into capacity too, as we talk about where these things can kind of go south and so on and so forth. But there is not just a one size necessarily fits all power of attorney. They can be used for a lot of different reasons and purposes. Estate planning can be one. Maybe you're just not in town to sign an important contract and you need to appoint somebody. So that might be a reason. But explain to us the difference in the meaning of general powers of attorney and limited powers of attorney? Because a lot of folks hear those terms, probably take them for granted, but what's the law really getting at there in those titles?
So just that, the general power of attorney is supposed to let you act on a broad scale. And it tends to use broad language. While a limited power of attorney tends to be, I am appointing my buddy, Andy Fowler, to sell the house that I have in Boca Raton. Okay, that would be a limited power of attorney. But a general power of attorney tends to be broader to encompass more things. I see a question up in the coming up in the profile there. What happens if it's not respected? Your power of attorney. Well, that a lot of it not being respected ends up being because the power of attorney wasn't drafted very well. That's part of it. The other part of it is just a skittishness in this day and age because there's so many bad actors. And who do you sue? As an attorney, you always sue the person with money. So if a bank makes a mistake, you want to sue and honors a power of attorney that's invalid and a bad actor stakes money. Well, you definitely are going to sue the bad actor, but they've already spent the money. And so who do you sue? You sue the bank. So people get really skittish. So my experience is when you're drafting a power of attorney, those who practice in that area, I have a whole team who does that. You have a team who does that. But those who practice in the area need to be both general and specific in the drafting of the power of attorney. So if you want someone to go and bank for you, you're going to say, I grant all of powers to my agent to act on my behalf with all banking matters or something to this effect. And then you're going to get real specific, including open accounts, close accounts, online bank, right? Receive my statements, write checks. You got to get specific, so like I drafted a power of attorney and for someone, and it had this broad language and it had some specific language. And then the bank comes back and says, well, it says all banking, but that's not really what that means. Right.
Yeah.
It says, and you're like, really, you can do, cut checks, but we're not going to let you open another account. Really? You're not going to let me open a savings account with that same money and put it in the guy's name? You're not going to, and each bank will make that decision on their own, what they will do. So if you're going for the general power of attorney, get specific. Don't hire a probate litigator to do your power of attorney. It was for my son. Okay. I was saving $1, but hire someone who is really good at creating the powers of attorney, because, the ones you can get from the Attorney General on these free websites or these for pay websites, they're okay, but they have the problem I just discussed. They're not specific. They're not tailored to you.
Well, I think what is a good point that you're making is that the power of attorney, though it is for the principal and agent, the reason why specificity in the document itself is so important is because the document is really for a party that's not even at the table there, really, right? It's for a third party that has to rely on that and act. So, the bank, the person at the bank's like, I don't know you. I don't even know this person other than their names on the account. And I know that law doesn't allow me to release this information. So I've got this one document that I have to rely on to make this decision about whether to allow you to write checks on their behalf. You can understand in that context why they don't want any ambiguity or vagaries in that language.
Oh yeah. I mean, I get it. I understand. Sometimes I'm a little irritated at them because, sometimes they'll ignore what the language actually says. You're like, open accounts on my behalf. I'd like to open an account. No, that's not what your power of attorney. No, it says open account. It's a very much a frustration in the industry, but I get it.
Well, and let's jump into another topic, because you did mention the idea of springing powers.
Yeah.
And I found springing powers, and I'll ask you to explain it in a minute, but also talk about how to maybe overcome this issue. I found that springing powers are difficult in two ways. The first is getting the medical professionals to cooperate with that, to give affidavits or statements. And then second is to get the third parties like the banks and the escrow title companies to accept the opinions of the medical professionals in order for that springing power to work. So talk to us about springing powers. And then also, if you don't mind, addressing, those issues that you have with third parties with the springing powers.
So I can see why you would have a problem with springing powers, and why by the time it gets to me, it's such a mess. I've never seen that. I could see why it is a problem. But you are stating a real problem in the industry, that a springing power, as you know, comes to life when someone lacks capacity. And what you want to do is you don't want your power of attorney acting when you don't want him acting. And so you say, hey, as soon as I'm incapacitated, make this power of attorney comes to life. And it's real easy in the healthcare situation, because, I'm lying there in the bed. All right. I can't speak. I can't think. I mean, that's pretty easy. I can't make a decision for myself. That's easy. In the general power of attorney, it's more complicated in the business stuff. And the power of attorney will usually set forth a recipe on the opinion of two doctors.
Mm-hmm.
Well, generally we have one doctor that we go to, and they don't want to write out anything that's going to put them in the line of fire.
Correct.
And these doctors are becoming more and more skittish. They're refusing right now to participate in the legal community because they're dragged into court to testify. And they don't want to do that. They want to practice medicine, but there's so much chicanery out there right now. Doctors have been bit, and they don't want to go back there, and they don't want to be exposed to the liability anymore. And so, and then when they do write a letter, they don't sit down and say, I have walked this person through their family history, and I've discussed all their children. They don't talk about those things. They say, this person could act or not act on their financial life. That's all they'll say.
Mm-hmm.
And they really don't understand legal capacity. That's not what they're trained in, medical doctors. So I could see that becoming a problem. Now, if you end up with that problem, there is a solution, and the solution is incredibly expensive.
Right. Yes.
So what you end up doing is you end up hiring someone who is adept at the problem, like me.
Right.
So, you guys, I'm certain do it too. But I end up hiring a professional expert. That report is about $2,500 to $3,500. And they sit down and they'll draft that report, and they'll take them through the battery of well-known standardized testing and explain how, explain.
Your expert's calling right now. He says you have it all wrong.
Yeah, this person thinks that I'm just terrible. All right, so what they do is they take you through a battery of tests, and they say, hey, I've tested this person. I've explained to this person I've had them explain various things to me. I've interviewed their family members. I've interviewed their professionals, their attorneys, their CPAs. And I could tell you that they don't understand the natural objects of their bounty. And I could tell you that they're incapacitated to this degree. And I could tell you that someone who has a high school diploma is generally going to test like this, and this guy's 20 points below that. But no one wants that.
Right.
And so that is a consideration when you're looking at your springing power of attorney, your durable power of attorney. Do you want it to be immediately effective? Do you want it to come to life when you're incapacitated? And that's a discussion. Once again, you can go out and you can go online and you could choose the magic power of attorney for $30 or $0 or whatever. But you need to have that discussion with a professional and understand what what the risk and benefits are and what your actual needs are.
Well, obviously the solution to avoiding the problem with the springing is to create an immediate power. But the inference there, and it's not just an inference, there's risks to every decision. What are they risking by just granting an immediate power?
They're risking the guy or the principal acting when they're not supposed to act. That's what they're risking.
Yeah.
When you don't need them to act, right?
When you don't need them to act. That's what they're risking. Yeah, but a lot of that has to do with, generally we choose our loved ones. And I hate to say it, but our loved ones ain't that great sometimes. And they don't have good judgment sometimes. And they act in self-interest sometimes. I mean, some of our loved ones are darn right crooked. Some of them are great, right? And we all hope we could trust our loved ones, but not always. So if I choose a loved one and that loved one doesn't have good judgment, yeah, I'm going to have an issue.
And I'm sure doing probate litigation, you've seen the back end of those issues. You've seen where the loved one has gone and drained the bank account, or the loved one has gone and sold the real estate and put the money in their pocket, right?
Oh, yeah. Yes. I see it. I see it all the time. Yes. Now, that's part of the problem. You're interviewing the wrong guy on power, right? Because I've only seen the problems. I only see the craziness.
Yeah. So for you're all about, you're like springing, because, there's a bunch of crooks out there in this world, and I see it day in and day out, right?
Well, yes, for everyone except for me, because, right. I mean, my own personal power of attorney is my wife, and it's immediately effective.
Right.
Now, I've been married for 26 years. I think I know my wife. I have a level of trust. Her power of attorney is immediately effective as well. But nonetheless, some people, I would lean toward, because I only see problems, I would lean toward springing and worry about the back end later.
Right. Well, since we're talking about the risk, and you mentioned kind of a question earlier that was getting to this, and of course I get this question every time I do an estate plan, whether you're talking about an agent, a trustee, or a personal representative, somebody who's going to have authority to act either prior to your passing or after your passing. The question is, well, what stops them from pocketing the money? And unfortunately, the answer to that is not that God strikes them dead with lightning. Usually that's not what's going to happen. They're going to have the power to steal your money, right? That's not to say that there aren't consequences to that, but what is the recourse and remedy to stop an agent from self-dealing like that?
Yeah, so it's really hard. It's very, very hard. I recommend that you don't. The first line of defense is there are no secrets. Clients, sometimes people have these relationships, and I know I'm going to be. This is just my opinion. Okay, you're going to find 5 attorneys are going to say 5 different things, but my belief is have an open door. And sit down with your kids, your family, your loved ones, whoever they are, and say, this is my plan. Hand out multiple copies and explain it, what your plan is. And say, even if, even if, Frank is not part of my plan, I might share a plan with him if he's close enough to me and understands me enough. So number one, don't have any secrets. Know what's going on. Number two, I don't see any wrong with appointing a co-power of attorney with one person, with the person who makes a final say. I don't see anything wrong with that. So you have two powers of attorney, but they could act independently, or maybe they can, or one could override the other. It does create a little confusion. It could become problematic, but that would at least allow one person to watch the other. It would take a co-conspiracy, because generally what people do is they start out with a little lie, well, maybe I'm going to just have lunch on Bob's dime, right? They don't start out with $50,000. They start out with, I really deserve, I've been working really hard for Bob, buying and selling his houses. And I really need to go down to Cabo and have a break. And so I'm going to spend a couple grand down. They don't start out with the big stuff. They start out little stuff. And, what my 80-year-old Bob Sewell needs to do? He really wants to go on a European vacation. So I'm going to take him and put him in the hotel the whole time, but I'm going to go out and hang out by the pool. These are the things that they usually start out with. So having multiple watchers, that's going to help. Choosing, if you don't have someone in your life that's really trustworthy, choose a bonded and insured third-party fiduciary. Mm-hmm. They're not that much, in comparison to getting your estate stolen, that few $1,000s a year. And when I'm to that point when my brain isn't working that well, and generally my life involves my house, right? I don't go out a whole lot. And so if you could pay someone a few $1,000 a year, maybe $5,000 to $10,000 a year to pay your house bills and ship out bank statements to your family members. And they'll be bonded. So if they do take the money, you could sue the bond. That's a good solution too.
So on the real estate side of things, we see this all the time, and I want you to kind of break down what happens. Husband and wife, married, own their home for 20 some years together, never had any issues, and husband gets diagnosed with dementia. And so they go and they put the property up, they put it under contract. The parties execute the documents because the realtor just wants their sale, right? They submit it to title, and something comes up about the husband signing, and the wife mentions the title. Oh, well, I don't know if we can get him there. He has dementia. And title's like, whoa, dementia? What's going on? Well, no. And next thing you know, title's like, we're not closing this transaction because we don't think, this person, we're not comfortable with their capacity to sign and sell this property. And there is no power of attorney, which, like you said, a $500 form, roughly, or whatever, would have solved it, but it doesn't exist. What happens at that point? How do they get this property sold?
It's a one-way ticket to a conservator. So if the person lacks capacity, if they didn't go to Fowler St. Clair in the first place and get their relatively cheap estate plan that included a well-documented power of attorney, if they didn't do that in the first place, then they should come to Bob Sewell, and I will gladly help them. And it'll be about 5 times as much. And I tell people that not because I'm mercenary, but because I want them to do the right thing. And there's going to be plenty of people out there who don't want to think about their death, don't want to think about their demise, don't want to think about their life plan, that I will never run out of work. Okay. So, but it takes a tremendous amount of work. And so you come to an attorney like me and I file a petition and I say, I've now paid the professional expert $3,500 to give me this beautiful report, judge. And the report says he lacks capacity. There's no power of attorney in place. Here's his spouse. I've now notified all their children. And we need you to appoint the wife as the conservator. And then from that point on, I have a relationship with the wife of several $1,000s a year as we go through the conservatorship process, and the court monitors how all her money is spent. Their money is spent.
And doesn't the husband does the husband not have right to counsel in this whole process?
The husband gets an attorney, and those attorneys come with greater or lesser degree of skill.
But who pays for that attorney?
Oh, the husband.
So it comes from their money too. So now they have you representing the wife, and now the husband has to have his attorney. I mean, I think that's the law, right? They have to have somebody representing them. And so now you're paying two attorneys for this process.
Right.
Oh boy.
It's not, and then that attorney never goes away. For the husband, theoretically doesn't go away. And every year we have to submit accountings. And the court then scrutinizes how the money's spent. And they generally don't look that hard if everything looks normal. But once something looks abnormal, she went to the casino. And a lot of people go to the casino.
Yeah.
Mm-hmm.
She took an expensive vacation. Once things look, well, wait, that's a lot of money. Once something catches their eye, it's more than just the water bill, the phone bill, all your general expenses. Then, and you get on the court's radar, you never get off the radar. And it becomes a challenge.
Well, yeah.
It's so much easier just to have a well-drafted power of attorney. So much easier.
Yeah, for sure. So let's talk about, once we have the power of attorney, we'll assume it's enforceable. They had capacity. They did it all the right way. If the family member I've chosen, maybe it's not my spouse anymore because they've passed or whatever the case may be, but I've decided it needs to be changed. Am I stuck with that appointment forever? What can I do to terminate it or change it?
Oh, no, you could change your agent under the power of attorney as long as you have capacity. And generally, you want to have backup powers of attorney in your document, at least one, if not two or three backups, because the powers of attorney I see, I choose my wife as my first one, right? That makes sense. And up until the fact that if my wife gets dementia and I somehow stay active and fit. And who's my backup? Well, I need to have a backup or two beyond that. So you generally can, as long as you have capacity, make a change. And with the backups, if I see, if I'm, I'm the good son and the bad daughter is my dad's power of attorney, and she has been working at McDonald's her whole life, and she lives with dad, and suddenly she's driving a really fly Maserati, kind of like the ones that you guys drive, right? Oh no, you guys would be driving the Ferraris. Okay,
The Ferrari.
It's kind of like the Fowler St. Clair firm Ferrari. Okay.
Yes.
She's driving that. Well, come on, right? We know where she got that money. So then the good son could go in and petition the court and say, remove her, make me the agent under the power of attorney.
Now, let's say somebody either amends or revokes their power of attorney and says, okay, I'm done with this, or I'm going to amend it. I'm going to take off, a child or an agent that I don't trust. I'm going to put somebody on. Now, at that point, presumably they followed the Bob Sewell, no closed doors, handed everything out. Everybody has copies of the original power of attorney, including the agent that they no longer want to serve as, in that capacity. What's the process to put the world on notice of, I revoked it, they're no longer my agent, they can't act on my behalf? How do you go about that?
Yeah. So, the good old days, I would record my power of attorney with the county recorder back in the cowboy days. But we don't do that anymore. You just tell people.
Right.
I mean, there's no legal requirement of what you can or can't do. I generally say you got to tell people. You just send out the email to tell, explain why you did it, explain why you revoked it, and tell as many people that are at all concerned about what's going on. I want to tell you a funny story about that. So back in the day, I had a when I was first getting started in this area, I had this case, and mom had a piece of crap son. We're going to call him piece of crap. And piece of crap.
That's Mr. Piece of Crap to you.
Mr. Piece of Crap, right. So crap, the bad son, he was a bad dude. Like, mom got ill and he couldn't be bothered. He takes her to the emergency room, drops her off. She's in a wheelchair and she can't take care of herself. Drops her off and says, "Hey, you have a good time, Mom. Now that you're in the emergency room, I got to go smoke my pot and have a good time." Right. And that was him. And so the mom reaches out and says, "Hey, 6 other children, can you take care of me and help me?" And they said, "Yeah, sure, Mom, but you've loved this guy more than us the whole time. If you want us to take care of you, you got to change your will, because we want to take 2, and you have everything going to this piece of crap, and you got to kick him out of the garage. He's been living in the garage because we're not going to move in and help you and live with this jerk." And she says, "Done." And she goes out to her attorney and she creates a new will. And the attorney helps her draft a letter. And the letter says, "Dear bad son, you've been a huge disappointment to me. And I have now cut you out of the will because I need someone to care for me. And you stink. Signed, your loving mother." Okay? Something like this. It was over like 2 pages. And so at this point, the son is pissed. And he brings action against his siblings. That's called it's called intentional interference with an expected inheritance. Okay, so really a bummer action. He brings it. He sues his sibling. Said, "You made mommy cut me out." So of course, I'm defending this case, and the first thing I do is I subpoena the mom and I say, "I want to see that will." And we look at the will. You know what? She never cut him out. She never cut him out. She lied to her kids. He was still in there for an equal share.
Oh, wow.
So, come on, man. This is what I'm talking about. Be open. Be honest. Tell your kids that you need help from. You know what? Yeah, he's a jerk. I still love my piece of crap son. And I'm going to keep him in my will. And if you want to help me, great. If you don't, I'm sorry. That's hard when you're the one that needs the help, but
right.
Be honest.
Mm-hmm. Mayu, I know we got a couple questions. Why don't you post those for us and we can address them? All right. The first question: if I buy a property subto and the seller dies before the mortgage is paid off, will the power of attorney be invalid?
One more time?
If I buy a property,
if they buy it by wrap financing, So they basically keep the existing mortgage in place and wrap it with seller carryback financing. And the seller dies. So the seller generally will deliver, like in those transactions.
Yeah. Oh, like a contract for deed situation.
Yeah, kind of like that. Yeah.
Yeah, your power of attorney is ineffective, and that guy's estate is going to have to make the decision. So if the buyer outlasts the seller, that comes up quite a bit, because not a lot of people do these anymore. Old folks like to do them. They did them back in the day a lot more than they do them now. But it does come up. So yeah, the power of attorney is ineffective at death. You're going to want to see a trust and a successor trustee in this situation, and you're going to have you're going to want the successor trustee to be able to act to release the lien and provide the deed.
Bottom line, powers of attorney work while you're living, stop working the moment of your death.
That's exactly right.
Yeah. Maya, do we have another question? If I find a property that's currently in probate and I structure an agreement with the heirs to purchase the property, do I have to wait till probate is complete before closing on the property?
No. Once probate's open, you can close on the property.
Yeah, really, in a probate, the very first thing that happens is the appointment of a personal representative who at that appointment has the full power to act, right?
Right. You open the probate, and the purpose of opening probate is to sell the assets, distribute the assets. And so by definition, you have to do all those things, sell, distribute before you close. And you can't close until you distribute. So you don't wait for the probate to close, but the closing waits for the sale.
Right.
Yeah. Good info. Mayu, do we have any other questions? Here we go. What are next step? Let's see.
What are the next steps? As the power of attorney document is not being represented by a company, to cancel the old insurance. That's a tough question because I don't quite understand it. Generally, though, let's say Bob Sewell has a company, Pencils R Us LLC. And I want someone to be able to manage my company. I'm going to write that into the power of attorney, so that my agent can make himself the power of attorney, the manager under my LLC. So if you don't have it structured like that, you're going to have an issue.
Yeah, I think the question is, so they have the ability to transact on behalf of for insurance purposes. Under the power of attorney, but the insurance company is not accepting the power of attorney, despite the fact that it says the agent can, obtain, cancel, deal with insurance. And I think it gets back to what we discussed before, which is there's what the law provides and what third parties will accept, and they're not always the same thing. And so you're going to have to, unfortunately find another way around it.
Yeah, you have to find a more cooperative agent.
Mm-hmm.
Mayu, any other questions? Okay, if I buy property subto in my LLC, another seller financing type question, do you recommend the power of attorney having my LLC on the document or my actual name? Raise a lead. They're asking due on sale clause questions, right, Sean?
Can an LLC be an agent, or does it require it to be an individual?
That's a great Fowler St. Clair question.
I think it has to be an individual. I don't think an LLC can be an agent. I think an LLC can be a successor trustee of a trust, but I don't believe they can be an agent under a POA. That it has to be an individual.
Okay, you're 100% correct. Yeah, the power of attorney is a statutory creation. It's a function of Arizona law. And now that you said it, you're right. Individuals are appointed agents under the power of attorney.
Yep. Any other questions, Mayu? I think that's our questions. Bob, we really appreciate you taking your time. You've been very generous with it. Tell our listeners how they can find and connect with you.
Okay, so yeah, I got a website, www.evenlegal.com. That's for my podcast. I also have a company website, www.davissmiles.com, and you could reach me at 480-733-6800.
All
Guys, thanks
right.
for having me on. It was fun.
Yeah, thank you.
Yeah,
Thanks for
yeah,
coming
we
on.
really
It's fun.
enjoyed it, and let's do it again.
Yeah.
All right, with that, everybody, thanks for joining us. We'll see you next Tuesday, and see you this afternoon at the Collective. Have a good one.
Have a good day, everyone.